Fantastic. So, welcome everyone. My name's Kendra Bosworth from ACSL. I'm Manager of Professional Development and Programs, and I'll be facilitating this session. If you've got any questions, need any support, please reach out to me, or we have Sheridan here as well from ACSL to help through the chat box. We're going to start with a prayer and reflection. In the name of the Father, Son, Holy Spirit. Amen. Gracious God, provide us with a listening heart so we may see and hear the voice of children and adults at risk. May our organisations, authorities and families listen to, respect and do what is required to keep children and adults at risk safe. We ask you to help each of us to exercise our duties with compassion, integrity and clarity as we work together to enact real change and uphold the safety of all who come in contact with our church and communities. Amen. I recognise that I'm facilitating this session from Ngunnawal country and the traditional custodians of the various lands on which you're all joining from today. We honour the First Nations people's culture and connection to land, sea and community, and we pay our respects to elders past, present and emerging. ACSL also acknowledges the lifelong trauma of abuse victims and survivors and their families. The failure of the Catholic Church to protect, believe and respond justly to children and adults at risk, and the consequent breaches of community trust. And so please be aware that this session does discuss abuse, and therefore it could contain content that you find confronting. If you start to feel distressed, please use your own judgment and make sure you're safe. You can find support resources on ACSL website, but please take the time if you need it and obtain the support you need. So today I'm pleased to introduce our presenter, Jon Sleeman. Jon's been in investigation, compliance and enforcement and child safety protection. He's been a practitioner, a consultant and a trainer for decades, offering services in the areas of investigations, child safety, child protection and emergency management. And I don't mean anything offensive by saying decades, Jon, because it's absolutely a wonderful reflection of your expertise. Recently, Jon held the position of Lead Complex Reportable Conduct Investigator for Catholic Education Archdiocese of Canberra and Goulburn, where he investigated both complex and matters of a lesser threshold, recognising that they may still be categorised upon receipt of the allegation as reportable conduct. Jon continues to provide child protection and child safety services to the Catholic Education Archdiocese of Canberra and Goulburn, and many schools in ACT in New South Wales. But today, Jon will be providing his reflections as a reportable conduct investigator so we can learn more and improve our safeguarding practice from his considerable experience. So while Jon's doing all of the talking to start with, we want to hear from you. So any questions, can you put them in the chat box? And at the end of his presentation, we will field those questions through to Jon and present them to him. So all that being said, Jon's already sharing his slides, but thank you so much, Jon. Welcome.
No worries. Well, thank you very much, Kendra. Much appreciated. Hopefully everyone can hear me okay. Excellent. Fantastic. No worries. Well, great to be here and great to have the opportunity to present in terms of this very important area. As Kendra so kindly noted my background, I'm getting old now, as my kids keep telling me every day. So yeah, I've been in this space for some time. I was in the AFP for a long time, about 12 years or so. My skill is complex investigations, and I was also a lawyer in the AFP and a trainer as well. Then I sort of fell into the RTO sector and then the consulting sector, as we do, and into the child safeguarding, child protection area. I spent 7 years as a consultant and staff member with Catholic Education Canberra Goulburn, and I had my own consulting practice on the side, and then it just got too busy, as these things do. So about probably 15 months ago, I went out on my own, and that's what we do. I have a number of consultants who work for me, and we run on average anywhere between 10 and 20 investigations at any one time in reportable conduct and so on. And I do a lot of work with faith-based organisations throughout New South Wales. I also do a lot of work with Anglican Diocesan Services as well. and in the out-of-home care sector as well, and in childcare as well. So hopefully have a bit of perspective, and then also work with regulators as well. So currently I'm working a day a week with Access Canberra, in coaching and mentoring their I suppose their compliance investigation team, not in WWDC, so WWVP, because that would be a bit close to home, but in the other areas that they do as well. So today I'm going to go through reflections, and when I was putting together, it's a really, I suppose, interesting exercise to reflect on where you started and where you came from and what you learnt on the way. And I think that's, for me, hopefully a benefit to everyone. So the first slide is I just want to bring out the idea that I think one of the challenges of RC matters is managing expectations, is keeping it simple, and ensuring that people actually understand what you're doing, and hopefully people here would have the same experience. I think the more complex organizations are, particularly faith-based, um, it is a complex space. Is that fair to say, where we have lots of moving parts? And that is one of the complexities of reportable conduct, is that when we're dealing with complainants, parents, regulators, and so on, victims, is that and respondents, or PSOAs, as we call in New South Wales, is just understanding what's going to happen in that space. One thing that I always say to clients is that we've got to simplify things down as much as we can. We've got to have the one-page fact sheets to explain what the reportable conduct scheme is and what that means for that person and what that means for their parent as well. So just something to think about in that context, because I think that's a pretty common experience we probably all share. And that goes to the heart of your governance and your systems as well. Um, it works better if we're in the same direction. I'm sure we all have experiences, particularly in large organizations, where we're not working in the same direction. Um, One thing I certainly found in faith-based is that we sometimes have a tendency, if I put my school hat on for a minute, that we jump into being a rescuer. Would that be fair to say? So we have a complaint about possible RC, and then the principal or AP says, that's fine, I don't want to damage a relationship, so I'm going to deal with it. In the process, they contaminate evidence or talk to different parties, and then it makes it really tricky as the investigator to come in and go, what do I do now? Because this is what's happened. To me, that's actually about understanding the scheme, and that's about getting before the principals, for example, or your persons, your frontline staff, and saying that you have a really key role and you've got to work with us, because if you don't, then it makes it very difficult to manage that downstream. So I just want to sort of talk about that. I think that's always moving in organizations in terms of the same direction as well. A reflection that I like to do when I do training for outdoor education and different schools and so on in this space, is that where are you in this journey? And I think it is a journey. Um, I've been involved in child safe audits with schools as an example, and I've got an audit approach where we look at the 10 standards, and for example, that for number 6, a child-friendly complaint system, or standard number 4, for example, that people are coming in saying we have a child-friendly complaint system. Now, I would argue that's a pretty complicated thing to have. Would that be fair? Because there's a lot of nuances to that. There's vulnerabilities, trauma, culture, different age groups, all that sort of stuff, or vulnerable people at the other end of the spectrum, obviously in terms of the Catholic safeguarding standards. So again, we need to, I think, in my view, think that this is always a journey. It's very difficult to have a perfect system in this space. The other point which I like to talk about is the James Reeson work, that I think, having done reportable conduct investigations now since about 2016, so nearly 10 years now, is that James Reeson has a really good piece around work health and safety, and the idea that when you have an incident, it's really like a Swiss cheese. I think for RC that's very true. Would that be fair? And happy to have a show of thumbs up, because I think that's my experience, that you have the incidental stuff that comes out, absolutely, but often you have stuff that there's little red flags, or there's little lack of understandings, or for example, we take the a school context, the teacher, I call it, who's too cool for school, and they like to joke with the students, the young people, or the youth minister or whatever, and then there's an allegation of sexual innuendo, and you go, you know what, that hasn't happened overnight. Is that fair to say that they would tend to have a tendency to do that? And we haven't actually done anything about that in trying to bring that to their attention. They may not even aware of the risk that's attached to that. So I think that's a really important point to always feedback for reportable conduct. With some of my clients at the end, I'm not sure if people do the same here, is we do recommendations in terms of areas of improvement, to recognize that, where are things we can get better at, because ultimately, and that can be part of the report, or that can be a separate document depending on the risk profile and the approach to the organization. But really, that's important, isn't it, to go, where do the risks lie, and how do we improve our practices in that space? Potential high risk areas. Now when I do training, I've developed this little approach. It's anecdotal, can I say? So it's not based on stats as such, but I use my experience to go, where do I think the risk areas lie? And if we think of this is as an example in an outdoor education school camp context, then we would say that, there's probably different areas of your business that are going to be higher risk than others. Would that be fair? And they're going to be higher risk for reportable conduct than others. So doing work in the out-of-home care sector, there's a lot of risks attached to out-of-home care. Would that be fair with residential facilities, foster care, and so on? In the faith-based and clergy side of the house, there's obviously lots of risks attached to that as well, and so on. So, and schools again, and childcare, and again. So we've just got to think that through and understand where do our risks lie and focus on our risks. I'm involved in writing policies and procedures over many years now for organizations. And what I find sometimes is we're focusing on the what if as opposed to the more likely. And what I would encourage you to do is really keep focusing on the more likely. And I'm a big fan of the traffic light system, the green, amber, the red, and focus on that because you can't pick the what if. Does that make sense? But you can pick the more likely, and then you can obviously base your training and your systems on that sort of stuff. So just an observation in that space. Areas of reflection. I'm going to talk about 10 areas of reflection today. Um, and the first one talks about the link between good practice. The second one's about red flags. The third one is about consistent approaches to managing RC matters. The fourth and fifth are about staff members and managers understanding of reportable conduct. The six is about designs of approaches to RC. Keep it simple, please. Seven is clear understandings of level of responsibility as to who does what. The categories for number eight, record keeping and quality of investigations. There's a lot there, but I'll just talk about a few points to each from my experience in that space. I like that picture over there of stats and so on. Reportable conduct's not a stat area. Does that make sense? We're dealing with real people, aren't we? With real situations, with real incidents, with real emotions. And so we can't make it mechanical. And I think one thing I've learned over the years is that as an investigator, you've got to have strong communication and skills to be empathetic. Is that fair? That is just really, really important. You've got to be able to manage very difficult conversations at times. But sometimes if you're too black and white, in my experience, investigators struggle in this area. Would that be our experience? Because it's not black and white often these cases in this space. So number one, connections to good practice. I think it's fair to say in a lot of investigations that you do is that the practices being adopted aren't great, and therefore the reportable conduct matter arises eventually. And really, what's happening is the practice of the particular person in their context is actually by not following good practice, that's actually contribute to the reportable conduct matter arising. And that might be how they interact with their children, young persons. It might be the understanding of trauma informed or the understanding of sexual boundaries or professional boundaries or whatever. But I think one thing I always say to organizations, if you can push that good practice, I would argue you're going to have less reportable conduct matters over time. Would that be fair? Because we have stronger training, we have stronger early intervention, and we start really addressing the risks that lie, which obviously contributes to best practice because no one wants to be subject to an RC matter. Up the right-hand corner, I've got able, willing, not able, and not willing. And I think that's a really important point. I'm sure in your organization, you've all got people where they've got limited capacity or capability. Would that be fair? And we've got to then assess that and work with that person to develop them the skills. But equally, we've got to have those tough conversations that if that person is not the best person in that space, then we need to obviously do something about it. Because if we're going to, for example, leave them in a residential care facility and we know that they struggle to deal with a young person who has significant trauma, let's say ADD, ASD, ODD. So we have all the Ds sitting there, which I know Sheridan would love. And in that space, that's complicated. Is that fair to say? So if that person doesn't have the skills to understand what they actually are, how are they going to manage it? I recently did an interview with a staff member for a childcare early childhood matter where it was dealing with children with that sort of background. And one of my questions was, what is autism? And the person couldn't explain it to me. Okay, what is ADD? Couldn't explain it to me. That's a gap straight away, isn't it? That if you're actually supervising and working with those children, you've got to have some understanding what that actually is. The other side I would say is what we do is we then develop personal plans, don't we, or behavior management plans or BSPs or whatever, depending on context. But the person has to have the ability to understand those. And equally, that often it's very common in a lot of the sectors, and out-of-home care is a good example from a therapeutic perspective, where you've got these 30-page but BSPs. Now, in reality, and I used to work for Sheridan many years ago at Cath Ed, we had many conversation around we've got to simplify that process to a one pager. So therefore, we can still have the 30 pager, but we need the one pager so the staff member who comes on shift or the casual can actually be briefed on it and see very simply how do they deal with John when this happens. They don't have time to read 30 pages. So just an observation. I am finding with the increase in complex behaviors, that's pretty common. Where we're having a lot of these plans which are developed, and the flip side is, do our staff really understand what that plan means and how they deal with that situation? I'm not sure. The next one is seeing the red flags. I talked a bit about before, and the idea that you see through the nature, through the forest or whatever, and recognizing it and dealing with it. So as I said, people don't want to be subject to RC, but we need to also recognize in a lot of activities that looking at where people come from here, you will have risk areas which are higher risk. You're running camps, I imagine. You've got children, young persons, and trauma backgrounds. Out of home care sector type backgrounds, whatever that might be, there will be red flags in that context. So therefore, we've got to think about we need to recognize those red flags. It's not uncommon, as I said, investigations to have experiences where Jack always does that. That's just the way Jack manages things. Okay, great. But what about if we actually try to get in earlier so we don't end up in an RC matter in that space? So I think that's one thing I'd like you to think about. And that's going to go to when I talk about managers a bit later. I actually think managers are the key in my experience in reportable conduct. I'm about to do a program for a client in the early childhood space now and after school care space around managers, I suppose, role in reportable conduct matters. And my experience is that if your managers are switched on and understand reportable conduct and understand a bit more than the average person around the categories of reportable conduct, they're probably better placed to actually deal with it front line because they actually know what attributes and what characteristics people have and also what their gaps are. If we don't deal with that, that's obviously where matters come um, in relation to that. A consistent approach is essential. Okay, I think many approaches I've seen with reportable conduct, and myself included, I've been part of that and as well, is that I was working for Cath Ed, I think as a consultant at the time actually, where the reportable conduct scheme got introduced to the ACT. And so having done it for a little while, I designed an approach where we thought, well, we're not sure with a small team, I think it was two at the time, we're not sure we can support schools with the amount of RC matters we thought might occur. So I designed a whole approach around basically choose your own investigation, like choose your own adventure, and then for a school principal or an AP to do a reportable conduct investigation. We rolled it out. After 12 months, we realized it wasn't really working because they weren't doing investigations very often. And even if we did training, if they're not doing it very often, the quality of the reports coming in wasn't where it needed to be. And then we obviously have extra regulatory risk that kicks in as a result of that. So with that, then my question is, or my suggestion is we've got to be consistent what our approach is. Whatever that is, we need to think about how do we run as an organization. The larger we are, we might try and then obviously have more frontline staff involved in these matters, and that's great. But then do they have the capacity or the skills to do that? And what is that going to mean in that space? So for example, I had a matter many years ago I had to advise on where there was an incident at a camp of sexualized type, I suppose, behavior. And the school leaders brought all the witnesses into a room and interviewed them all at the same time. Now, as you know, that's a big no-no. We can't do that. The evidence is very questionable. That came down from a lack of understanding in terms of and processes and thinking, how did we get to that point that we thought that was the appropriate process in that space? And so just something to think about there. Um, Early intervention we talked about, rescue we've talked about, and fit for purpose. The policies and procedures, which we'll talk about a bit later, has to be fit for purpose, in my view. It's got to be something that people can actually understand, because the more complicated it is, as we know, the more challenging it is for staff to follow it. In my experience, that affects well-being, and I'll talk about that in a moment in that space. The other point is I'm conscious that in Queensland, for example, I know that the scheme's coming in, I think it started July. And I know from a business perspective, myself and one of my consultants in Gold Coast, we're looking at sort of moving to that market. But I think one thing that in my view is you've got to get in early for those organisations operating in Queensland. If you haven't already, is thinking about what is your approach to RC? What are you going to do? What is your triage process? How are you going to manage this? How are you going to brief your staff on what reportable conduct is having lived through the ACT experience, and I imagine Queensland regulator might be quite similar, is they'll do lots of training around reportable conduct to child-related organisations who are subject to the scheme. But my experience is that, and I'll be interested in a show of hands if that's the same, is that when you do a reportable conduct investigation, it's not uncommon for people not to understand what a reportable conduct matter is. That's a pretty common experience in that space. And so what that means is that tells me that the training we're doing through online training, whatever, is not hitting the mark in that space. And the question is, how do we actually get people to the point that they understand that this is what an RC matter is, and that's what's going to happen as a result of that process? Which leads me to the next point, staff understanding. I thought these pictures were quite um, useful. And again, interested in show of hands if people want to around. We want to have the green wall, so it's nice and neat. We don't have the messy. But then I think the heart and the fear of suffering is really, in my experience, common. So an RC allegation gets made, the staff member thinks they're going to lose their job. That's it. And that's pretty common as probably also have that experience. If you look at statistically, it's probably quite unlikely they're going to lose their job in a lot of matters anyway. But that's where the fear kicks in that this is what's going to actually happen. And therefore, then they start questioning the process and wanting the investigation over in 2 days. And as we know, we'd love it to do it in 2 days, but it doesn't happen in 2 days. Although funnily enough, I did see an organization about 12 months ago where was saying they were going to knock over investigations in 30 days. And I thought that's pretty optimistic in reportable conduct matters, from my experience, because there's always lots of things happening in that space. So again, staff understanding is key. So how do we make or help staff understand what reportable conduct means and that there is a process and they will come through the other side. It is going to be stressful. Absolutely. But we want them just to take their time, think through the process, and so on and so on. And then we can come out the other side. So just something to think about. A good example is a matter I'm only doing this week, which a client wants me to push through quickly, which is fine, is that the particular staff member's been in the sector for 30 years, first reportable conduct matter. And then I got an email today saying, oh, is this going to affect my working with children clearance? Okay. Now, it's interesting that, obviously been involved in lots of training over the years, but again, it just shows you when you're under stress, obviously those things you're not understanding. Now, because all our areas have staffing challenges, do you think that affects staff wellbeing and staff retention? Because I think it does in my experience, like absolutely. So if we can do that better, in my mind, that's really, really important in that space. Um, I've just got an example here of the different, I suppose, characteristics of child safety, and that's the way I look at child safety. But I think that's important that, again, we're ensuring our staff just understand that reportable conduct is just one part of child safety, but that's an accountability type perspective in that, as to what that actually means. So just something to think about in that space. All right, managers, they are the key. The challenge in managers, I think, in a lot of our sectors is that they're pretty busy people. Does that make sense? They've got lots of responsibilities and competing interests and whatever. Um, but they're your front line, aren't they? So if you're not getting feedback from your front line about capability, capacity, competence, then obviously then the risk can increase quite significantly in that space. So I think in my mind, we've got to target the managers around reportable conduct and try and assist them to understand the key role they have in that space. They need to have, in my view, a greater understanding of the categories of reportable conduct and what that actually means, depending on your jurisdiction. The link to well-being, the link to risk, which is really central, obviously, in terms of how you do that. And then when they're, for example, approving activities or whatever, they've got that reportable conduct lens on a little bit to go, well, if we're going to send all these students out into a school camp, for example, well, we've got a duty of care, risk or neglect that sits in reportable conduct. And so are we comfortable that we're taking all reasonable efforts in that space? Maybe we are, maybe we're not, but these are things we need to think about in that space. So that's just an observation there. That I think is quite important in that context. Um, with managers, the other thing I would say is that a challenge you often find is, I think, managers' ability to, I suppose, to manage conflict or to handle conflict because they don't want to have that difficult conversation with a person, which I know is really tough. But ultimately, is it fair to say that if we don't have that difficult conversation, then that's where we end up with a reportable conduct matter downstream. So I think we've got to upskill managers in conflict resolution, which I know is really difficult, having difficult conversations, coaching, all those things, because I think it's not going to stop all reportable conduct matters, but I suspect it will certainly reduce matters. In that context as well. So I just think that's one of the challenges in this space. The other thing I would say is that increasing report managers' understanding of reportable conduct processes and the role they have. So I know some agencies use case, I suppose, case managers, what they use that term or something like that, whatever you're using. The idea that you have an RC matter, then you have a HR member who manages the case. In my experience, it's the frontline staff who do the heavy lifting. Would that be fair? Show of hands if that's the case. So it tends to be the managers who are dealing with the staff members if they're not suspended or even if they are suspended. Um, Suspension is, as we know, a gap that happens quite often where a staff member gets suspended and then you often hear back, oh, no one's contacted me for 2 weeks or 3 weeks, or I don't really know what's happening in that space. And often I think that comes down to the fear of the manager thinking I'm going to contaminate the process. But if they're trained properly, they're not contaminating because they're not talking about the investigation. They're talking about well-being, aren't they? And that sort of stuff. It's a different context in that space. So that's just something to think about is how do you approach your managers of reportable conduct? If we take a school context, how do you teach principals and APs about what their role is and what that actually means in that context as an observation? Um, Design of your approach to report or conduct. So I talked a little bit before about policy and procedure. I've seen lots of, I suppose, designs. I think one area we can improve is instant reporting. Would that be fair? Where it's, we probably all come across matters where you can see on the face of it that's clearly reportable conduct as a starting point, and it doesn't get reported. Equally, you have matters come through where it probably isn't reportable conduct, and we do report it as well. So I think with a bit of sort of thinking quite clearly, we can actually develop better systems to manage that, and then we can more effectively triage. So, for example, I've got clients who have really are developing really great systems they already have where they have panels of reportable conduct, and therefore a possible RC matter comes in, gets considered by the panel in terms of what that means. If it doesn't reach threshold, they make minutes or notes of why it doesn't reach threshold, and they'll handle that by code of conduct or informally or performance management, whatever they do formally. But in saying that, if they then get audited by the regulator, then obviously they've got that record as to how they made that decision. And I think that's a really effective way to do that. So again, in your organization, have you got those systems? Because I think that that gives you more comfort in terms of saying yes, but saying no. I think one of the challenges we have in the sector at the moment is on the back of the child safety stuff, but is it fair to say to Victoria and New South Wales and so on? Parents are fairly nervous. Would that be reasonable? And again, show of hands if that's what you're experiencing. So there's a lot of nervousness out there. Um, and the challenge with that is that there's an expectation we're always going to be doing a reportable conduct matter, when in actual fact we have a really low level, it might be quite low level. So New South Wales, as we know, doesn't have a class or kind scheme anymore, which I actually quite liked, although it has a sort of equivalent in terms of how you assess it. ACT is the same. But from a resource perspective, that makes it hard for organizations because we're then investigating stuff which is pretty low risk in the big scheme of things, but that's tying up resources and obviously financials and that sort of thing as well. So I think we've got to get smarter with our schemes around the panels and making a clear assessment that on the face of it, this is not reportable conduct, and we've made a decision. What we can also do is we can go to the regulator. Now, interested to share experiences. The challenge when you go, like we do that, but the challenge often when you go to the regulator is often you're told to investigate the matter. Has that been our experience? And so often you end up investigating anyway, where in actual fact you're saying, hey, it's not RC or we're not really sure. So these are the complexities of that. I suspect for Queensland, and show of hands, so we got quite a few organisations operating in Queensland, maybe. Yep. Okay, we've got Lee Mate operating and a few. Yep. Okay. So one thing I'd say with that is from my experience, quite a few, is that I suspect it's going to take a while for the scheme to mature, if that's a reasonable suggestion. And that certainly was the experience, I think, in ACT. It just takes time. And what that means is matters are getting assessed as reportable conduct, which probably shouldn't be reportable conduct, or conversely, probably should be reportable conduct and they aren't reportable conduct. And sometimes you're getting inconsistent decisions as to whether it is or it isn't RC. So what I would suggest for those Queensland organisations, and happy to chat offline if people want support, is that really work hard on your triage processes, really work hard on working out how you're going to handle these complaints. And for your frontline staff, that as I said, they have that understanding as to what that actually means, because that way you get more consistency. I saw a question, triaging, centralize, absolutely, if you can. The complexity I found in school systems, as an example, is that you want to do that, but often stuff's not coming through. And that comes down to a lack of understanding of the scheme. But I agree, absolutely. If you can centralize it, makes such a big difference. So you want to be linking that to your instant reporting that's picking up those matters and go, hey, that may be RC. And that allows us then to actually look at it and go, hey, is it not? And make some further inquiries within the reporting time frames of 7 days or 30 days or whatever. So in New South Wales, 7 days, 30 days ACT or whatever that might be. So I think we need to have a really, I suppose, a good process map, I suppose is what I would say, to really think about practically how we're going to do this process and what are we going to do. And I say that very genuinely because having done this for 10 years now, I can argue a matter is not RC and I can probably argue a matter is RC. Is that any other people's experiences in some circumstances? So if we call the line ballers, I call it when I do training, I think the line ballers you can argue in, you can argue out. So the reality is we've then got to have our risk profile as to how we manage that, but we also need to be consistent as organizations as to how we do that. The next point I make is understanding the executive about RC obligations. I think for our new organisations in Queensland with the scheme, I think the training is really important about the role of the exec, in that space. I think there's another number of things there. Managing expectations, I think that is so true that if we don't understand the investigation process, we may have the view that hey, an investigation is going to be over in 30 days. Now, I've been doing investigations now. I'm showing my age now for since 99, so what, 27 years now. And it just takes longer than you think. Is that fair to say? It's just what happens. So, whether witnesses aren't available or something else happens, or you've got a more priority matter that you need to deal with, or the one of the key witnesses, the complainant's a little bit reluctant whether they do participate. The respondent goes on personal leave or whatever that is. There's obviously heaps of things that happen in that space. And so we've got to manage our expectations earlier as to what that actually means with the scheme coming in effect. Are we going to have an influx of matters? When we had ACT, we thought we did. We didn't actually. So it's quite interesting. We sort of thought, oh, we're going to have all these matters come in. And that wasn't the case. Not saying that won't happen. But that was a different environment, 7 years ago to it is now. And the child safe, obviously, with all the pressure in organizations and the vulnerable persons as well. So I suspect we probably will have more matters than we probably did back then. That's just my feeling in that space. The middle picture is to depict delegations. Delegations is so important. You've got to protect your delegates in RC matters. You've got to protect your decision makers. So who is your decision maker? How do you ensure they don't get involved in the investigation when they don't need to? And then they can be free from bias or perceived bias or actual apprehended bias to make the decision, whatever that might be. And so your delegation structures are really, really important. I had a recent experience where I was asked a question around a board and I've had some matters in that context where what do you report to the board? Now, again, I think we've got to think very carefully with that, be fair, that does a board need to see every matter reportable conduct, or do we, for example, silo that to a member of the board who has a bit of a background in that space, and they'll be the board's eyes for governance perspective over that? Because if the board member needs to recommend a key decision of the chair, we want to protect that delegate from bias as much as we can. So I think we've got to be conscious in this space as to what that actually means. The other thing I'd say is procedural fairness. Now, procedural fairness, as we know, is always a moving part as to what is procedurally fair, what is not. And it depends contextually, in my experience, on the situation. But we need to obviously brief our board that when we have procedural fairness, that's going to, that because we need to follow that, that's going to slow down investigations. Is that fair? It's just going to. So, for example, some people say for a response to an allegation letter, 7 days is okay. Some do 3 days in my experience, which I think is a bit light on. That's just me. Some do 14 days, some do 28 days. I'm not sure there's a specific agreed time frame. I think it depends on the context of the matter, the complexity of the matter, and so on. And you just got to vary that depending on whatever that is in that space. So again, briefing our executive of what that actually means in that context is in my experience, really important. All right, the categories. I want to spend a bit of time on the categories. I think the categories is something that it can be difficult to understand because particularly categories like neglect and ill treatment, it really can be a catch-all into different things in that space. And the other complexity is we have professional boundaries, for example, in ACT. We don't have professional boundaries anymore in New South Wales. Although I've got a matter at the moment where I'm going to bring professional boundaries in through a treatment in New South Wales. So, there's ways and there's ways in that space as well. But in saying that, we really need as I suppose, your frontline staff, your organizations in reportable conduct, whether you're investigators or you're the case managers or so on, I think you've really got to have a detailed understanding of the fact sheets and really understand that how does it fit in, how does it not fit in, and do I have a reasonable defensible argument is really what it's about, isn't it? To say, well, I think it meets this, I don't think it meets this, and I could defend my argument to a reasonable level if I really need it to. So obviously sexual offense tends to be a bit easier in that space. Assault's a bit of an interesting one, like as to what that meets. Although, look, I'm certainly aware of matters where we have serious physical assault. That's a pretty high threshold to reach. And some matters may meet it, some matters may not meet it. Who knows? Um, but sexual misconduct obviously can be lots of different things. I think the fact sheets, say New South Wales are getting, they've only were redone September last year, are really good where they're providing lots more clarity. So when I do my reports, I always come back to the fact sheets. Is that our experience in what we're seeing for investigators or our own staff or externals? Are they always going back to the fact sheet to analyze against the criteria? Show of hands if we're seeing that. I hope we are. Not too many. Okay. I hope they are. So I'll just flag it. Yeah, with Leah's, that's good because in my mind, that's what you come back to. Coming from a legal background, it just comes back to the criteria as to whether it meets or it doesn't meet. And that's a criteria we use to try and explore that. So for in your organizations new to this who go into Queensland, for example, the fact sheets are going to be your key in terms of your investigations in that space. The other point I'd say is chasing a rabbit down the rabbit hole. Okay. I think one thing we learn in investigations over 30 years, and I've certainly made a mistake myself for many a time back in law enforcement, is that you have this idea that you want to know everything that occurred and you want to be able to work out sustain or not sustain in clarity everything that occurred. Now, in reality, you don't always get to that point. Is that fair to say? So with that, I think you need to then develop a practice as to what is reasonable in that context as to what you do. So to give you an example, in a complex investigation, I won't necessarily speak to every witness. Or if we take, say, a club situation, if we've got 30 kids, 30 students who witnessed an incident, I'm not going to interview 30 students. I had that discussion many years ago with the ACT Ombudsman, and we had that discussion, and I said, look, in my view, if we did 6 students, would that be reasonable? They said, yeah. And they decided that because my argument is if I interview 30 students, then the reputation of that staff member is gone. Is that fair to say? That's it. And so with that, then, I think that's a good way to do that is just say, well, what is a reasonable level? But then I have an approach with that is what I do take in a school context is I'll say to the client that can you pick me the direct witnesses and then can you pick me 3 other students who are sensible, if that makes sense, who you could tend to rely on their evidence and they'd be the best people to speak to in that context. So we get a bit of independence in that space as well. So that's the way we try and do it in that space, but we're not interviewing 30 students in that context. So again, it's just about what is sufficient evidence to establish on the balance of probabilities where we need to get to in that space. Significant and emotional psychological harm to a child. I haven't done many of those in many years. You tend to not do those. If you do, I've got one at the moment, then you tend to get into require expert evidence, and that gets quite complicated in this space, obviously. But we don't tend to do that as much because it's hard to prove that psychological harm comes from, say, one incident or whatever that might be. But again, it's all contextual to the incident in that space. Neglect, in my mind, is probably one of the hardest ones in some ways as well, because neglect is very contextual. Would that be fair to the circumstances and what's going to reach that threshold of neglect? And obviously the child protection system kicks into that as well as part of that as well. So there's that overlay in that space. So again, clothing, food, lodging, medical aid, nursing, supervision. Where neglect comes in my mind, is more supervision matters, is in my experience, because in a reportable conduct context, clothing, food, lodging, medical aid, nursing are probably less likely to happen, or the out-of-home care type sector, they can come up in that space. In a schooling context, hopefully less likely in that context. But the supervision/duty care, that's a big one. Is that fair to say? That's one that will go to the heart of those sort of matters in that context. So that's where my experience they tend to come up in that context. The categories I just included that to get provided to you guys. They're just some things I sort of use in terms of when I train it that I thought might be useful just to think of some of the common things. One thing I'd encourage you to do if you don't already is please look at the OCG, say, or the ACT Ombudsman or Queensland in a few years' time, or Victoria, WA, and so on. Look at their reports and look at where the matters are coming out of and where the trends are. And that's really useful to brief your executive about where our risks lie. It's really useful for a child safe risk assessment to work out, what are our risks. And it's telling us trends. So, for example, we can see here that assaults have gone up, okay, a little bit. Um, Significant emotional or psychological harm, ill treatment's gone up a little bit, neglect, and so on. So we're starting to get a bit of a sense of where that lies. In my experience, anecdotally, I think the biggest challenge in these sectors at the moment is complex behaviours. If that's reasonable, please do a thumbs up if you agree. I'd imagine there'll be a few. Um, and I think there's a lot of RC matters tend to come out of these complex behaviors. Although I think a lot of that comes down to, we've got to get better at our plans. As I said, understanding our plans, our planning, staff training in that space to try and reduce the incidence of some of these complaints in that context. All right, record keeping, a big one that I imagine everyone talks to their staff all the time about. It's pretty common in RC matters, having done this for 10 years, to have poor record keeping. Is that fair to say? That's not done contemporaneous, isn't detailed, has an opinion. Certainly, an opinion evidence is not uncommon. You know what? That comes down to training, in my experience. That's just training. Having templates, having examples that staff can actually follow to help them understand how they make a report. That's challenging because record keeping is not an easy thing to do, and we're busy and so on. But if we can't get that contemporaneous detailed record, which is objective, then that objective, which that makes a difference, doesn't it, to support a person and help you investigate a matter as well. So really want to stress that record keeping practices is doing training with your staff, setting the expectations for managers as to what they do, getting managers to review matters to make sure they actually review matters and understand what that actually means and how they can improve things and feeding that back to staff. What I find in a lot of the sectors we work with is that we're very responsive. Is that fair to say? So there's always a new crisis or a new bushfire. So we go from one matter to the next, and we don't get a time to go back and debrief over the previous one and look at how we can improve things. So again, just something to think about is trying to get more, I suppose, contextual with that space as to how we deal with those things. And quality investigations. Now, I thought I'd just talk for a few minutes before we open to questions. Is that I think there's a number of aspects to that, and I've been on both sides, and I think that's been interesting for me from that experience. And I've also been on the regulatory side as well, so I see that side as well. So I suppose it's an interesting perspective as to what that means. Um, Engagement, I think, is important, and is doing an engagement in terms of what's in scope, what is not in scope, where are we focusing. I say that because as an organization, you've got to guide me as to where you want to go, but you also don't want to give me enough, I suppose, free will that I'm going to follow every rabbit down every hole, and then we're going to end up with an investigation taking 18 months or 2 years, when obviously that's pretty hard to manage people's emotions and oversight for, if it's going to go for that long, which I've heard some of these matters go for. I haven't had one that long, touch wood, in that space. So engagement's really, really important in terms of having that briefing, setting out clear your expectations to the external, what that actually means. What are their resources? What is the experience of that staff member to do that investigation, and so on and so on. What is that understanding of the RC scheme? So do they actually understand what reportable conduct is? What is their system? So to give you an example, I have an approach which I know I've used previously when I was working with another organization, which we developed, where I have a report writer who does work for me. So I can get out there on the front line and some of my other staff, and then I have the report right in the background that can actually write it. We obviously got to settle the document and whatever, but that means we can turn around matters a lot quicker, which makes a big difference. I finished a matter last week for a client where it was 130 pages. It took so long. And the thing with that is, if you're doing those sort of matters, as you know, you're out of action for 2 weeks basically by the time you do that report. So that makes it difficult for your other matters as well. Planning. Investigation planning is really important. Now, the regulators have templates, so the OCG and ACT. Investigation plan templates tend to be a personal thing, but the bottom line is you want to see the investigation plan and you want to talk through it because it needs to be realistic. And having been involved in designing these, over many years, and I'm about to do the same again, Praxis Canberra shortly, is that I think with that is what's really important is that it's got to be fit for purpose and it's got to set out clearly what are you going to do? How are you going to do this? What is your process? What is step one? What is step two? What is step three? Whatever that is, so we can clearly articulate, we know what exactly is happening in that space. So would recommend the planning. We've talked about black and white versus grey. The only thing I would say is some investigators and coming out of law enforcement, we call it depolicing. And I think having seen it from a training sector as well, within police and outside police as well, I think it takes about 5 years to depolice, is my personal experience. And then when you get into a matter like RC, RC is so grey a lot of the time because no two matters are the same. Would that be fair to say? It's just the nature of it. And so you've got to have the ability to think outside the square a little bit, as to what matters are and understand what that means. Reporting. What is your regular reporting processes to clients is really, really important. So is external reporting to you weekly, fortnightly, whatever that might be, which I know is not easy at times. But we need to think about that. Allegation letters. I've seen so many different allegation letter types. We've probably seen all the same. If we put 10 investigators in the room, we're like lawyers, you'll have 20 different views on what's a good allegation letter and what is not. Um, I think the reality of allegation letters, it's one of my personal things, is the person has to understand it. That's the bottom line, isn't it? They need to, from a procedural fairness perspective, understand it. So we're conscious of our language. I was looking at an allegation letter recently that another organization did for some work I'm doing, and I think there was an allegation with the narrative, which was one page, one type page, just as paragraphs. And I thought, how does a person understand that when they're under stress and all those sort of things? So what about bullet points? Trying to break that down a little bit using headings, whatever, trying to help the person understand what that actually means. Can we, for example, do a background at the start, which I often do for my complex matters? I do a background in terms of the facts that aren't in dispute. And then after that, I'll go allegation one, two, three, four. So to try and break it down a little bit as well. I don't need to do it all the time, but as I said, only for complex matters usually. Investigation reports. Investigation reports are an art, I suspect, and we have different techniques the way we do this. I've seen lots of styles. I've seen child protection practitioners in that background prepare reports like a care assessment, which is sort of probably a little bit different to what we do in a more, I suppose, investigation context. I've seen people do it like, I suppose, police briefs with evidence as such, and so on. I think we'll have our own techniques, but one thing I would say is that one gap I often see is analysis, is that we're not analyzing evidence enough. We're not going back to the fact sheets, as I said, to the criteria, and then actually analyzing against that to say this is what this means, whatever that might be. And so one thing I encourage you is if one of my guys does an analysis and it's half a page and it's a complex matter, that's not enough. Like we've got to have some detailed analysis because this is people's careers we're talking about, and we've got Regis scheme and all those sort of things that kick in as well. So we've got to have some more detailed stuff in that space. The last observation I make for open questions, which I'm meant to put a slide in for, was I suppose Regis matters. So I'm doing increasingly more and more historical Regis matters for clients. They are obviously challenging because, in my experience, it's pretty unusual you get to interview a complainant in that space or a victim. Is that our experience we're finding? Thumbs up if that's pretty common. Yeah. So what it means is you're getting a bit of information. You're getting not much. Would that be fair to say as well that, this happened? You can't really contextually understand in any detail. My approach to that is I've worked out a bit of a system where take a school one, for example, where I'll get the school to check their records to try and work out did the staff member and the student interact together? Did they teach them? Were there any negative interactions that occurred that we can identify? We'll speak to some other staff around that space. And often we can't go much deeper because there's nothing to get. The bottom line is we just need to have a defensible position as to how we're doing that. But we can't interview every student. Would that be fair to say? We can't interview every staff member. So again, it's just got to be on balance of probabilities. I find Brigginshaw really useful in that space. I'll bring Brigginshaw into those matters because I think that helps you sort of get to that threshold to go that we can't get that high, and that helps you work out where you end up with them. But I think the historical matters are problematic just because you can't interview the complainant and find evidence of first complaint or anything like that in that context. Okay, and over to questions. I'll open the chat. I'm happy for you to read those out, Kendra or Sheridan, if that's easy for you guys.
I will absolutely read them out for you, Jon, if you don't mind. But thank you. I've learned a lot in there as well. I'm going to go through the questions quickly because I am looking at the time and we've got a lot of questions, which is great. As I read out the questions, if the person who put them into the chat wants to talk, speak up, please unmute yourself and talk. But the first one was from Tim Ross, who said, isn't a speak up culture part of a better practice? Therefore,
Yeah.
case numbers could feasibly increase rather than decrease, as you said, in an environment where there is better practice.
Yeah, agree. No, I agree, Tim. It's a good point. Yeah, I think it depends on the environment, but I think if you have more reports, that's a good thing. I've got that happening with my clients at the moment. They're getting more reports, and we're going, that's a positive thing in that space as well. I think it comes down to the reporting culture, isn't it? Is the organization happy or staff to speak up, and what does it actually mean? But no, I agree. I think it can go either way in that context.
Thank you. And Aileen said, um, oh, yes, you answered that as we went along. Sorry, about recommending the triage be centralised
Yeah,
or for a consistent
yeah.
assessment. So you answered that. Then Brenton asked, would you consider a single point of reportable conduct portal to a state government, probably police, as an efficiency and gives government a triage responsibility, and then let the matters be distributed to the relevant various government departments rather than sending the reportable conduct issue to several government departments?
Yeah, it's a good question, Brenton. That's come out a little bit in terms of obviously the Victorian stuff, and I know there's certainly in our sector different, I suppose, advocates who are pushing for that. Um, my personal view is probably no, because I can't see how it could be foolproof. I think there's been suggestions to have mandatory reporting tied up in there as an example. The challenge is you're putting a lot of responsibility in one agency to triage that. So I think in theory it's a good idea, but I think the amount of complaints you have will probably overwhelm that process in that space. I also think that you want to encourage people to make their own reports to police as well if they feel that they need to, and so we can sort of have the person have that confidence. But yeah, I think it's got a long way to go there. I think it may end up there, but I think there's got to be a lot of systems in place to get to that point.
Okay, thank you. Aileen has asked, do regulators in other jurisdictions, because she's in Queensland, have decision, do regulators have decision tree type tools to determine whether it's RC or not? She's hoping that the QFCC will release one.
Yes and no, to be honest. I think no one's. I think you sort of do and you don't, but you certainly don't have anything like, for example, the mandatory reporting tree that you have in New South Wales as an example. Um, so you really just have the fact sheets, really. The challenge we have, and Aileen, you'll find that in Queensland, I suspect, is that there is a view amongst regulators, having had this conversation many times, is that because they're allegation-based scheme, once an allegation's made, that's it, it's in scope, and it really doesn't matter. The rest of it doesn't matter. So prima facie, there's a view that it's an allegation, therefore it should just be investigated. But I'm with you. I think if you can feed back in, I think that decision tree is a really good idea, particularly for your low-level stuff, because what happens is you get bogged down the low-level ones, and then you don't have the time to provide a support to the high-level ones, which you priority, but also you don't have time to do preventive stuff. And I should have mentioned that one of the challenges I've found in reportable conduct when I was back in the systems is that we spend so much time doing RC matters that we don't get a chance to do preventative work. And you think that's a gap, isn't it? Because we want to get on the front line to deal with the preventative work, which means we don't need to do these RC matters. So it's a bit of a catch-22.
I understand where you're coming from with that, John. Vicky has asked, in my work, I found that really significant situations like family violence are captured by several reports. For example, child protection and reportable conduct and police. It can be hard to convince those responding on the ground that after following up the most urgent safety concerns, that reportable conduct is also a priority, especially when timelines can be slow.
Absolutely right. Yeah, 100% I agree with you, Vicky. We call that personal life matters. They're the most complicated matters in a lot of ways that you do, personal life matters. And this is the complexity. So what happens in personal life matters is the child protection agencies will provide a report, which you probably get across, and then you've got to go down the reportable conduct space. Do you interview the child or the parent and the staff member and so on? What do we do with that? So I agree. This is the challenge in this space is this whole area around multiple agencies competing against each other. And then we've got to do information requests to try and get information out of agencies. And as we probably have the same experience and happy to have a show of hands, sometimes we get heaps, sometimes we don't get much at all. Would that be fair to say? That's just the reality of the sandpit we play in. So I agree. It's not an easy area, that one.
Yeah. And the Yulula has said, is there any training available for RC investigations? Who's the best to complete the RC investigations? And can we share any links? They are in
Sure.
Queensland.
I suppose can't put my consulting hat on, can't comment for other organizations. But certainly, look, I have capacity in Queensland with but Nick, his name is based on the Gold Coast, so he certainly helps me with RC matters and has a good background in that. Um, I think the challenge is, I think as you move into this, some organizations have developed panels in this space, which can help. The challenge with panels is you're only as good as your investigator, in my experience. So you've got to have investigators who are experienced. To give you an idea, part of my practice that I do is we do complex child protection / reportable conduct matters in out of home care. And I've got one investigator who works with me who was ex-police, but also ex-DCJ as well. So she has a specialist set of skills and also worked in the out of home care sector. So she's the best one for those matters because she's worked across those three disciplines or agencies. So yeah, I think really the main thing is my view is they've got to have experience in doing RC matters to try and navigate through that as well.
Thank you. Brooke has said, at what point in the investigation do you feel an allegations letter should be issued to the PSOA?
Yeah, interesting question, Brooke. It does vary. Of course, it does. I have a two-step process, which a lot of places do. We have a notification letter and allegation letter. Um, I think if you can, sometimes you issue at the same time. For like the matter I did this week, I issued both letters at the same time just because we can move through quickly. Other times you're just going to take your time. I think it just depends on what inquiries you need to conduct at that point in time. However, if you've got witnesses you think are a little bit iffy in terms of providing a statement or whatever, then you might then delay that a little bit as well. So I think it's just got to be contextually for each situation, but you've got to have one eye on procedural fairness and the idea that you'll get a complaint if you leave it too long. And so sometimes you certainly have matters where just like a matter I know that lady's doing for me at the moment, where we did an allegation letter reasonably early, and then we'll do a subsequent allegation letter if we need to later on, and that way we can deal with the complaint that it's taking too long or whatever that might be. So that's the way we sometimes get around that.
Thank you, John. Last questions. I'm interested in the mechanics to engage an outsourced investigator. Could a pre-agreement be developed to have all the admin sorted for when an RC matter arises so the investigation team can be mobilized quickly?
Absolutely. Yeah, absolutely. And that's the way I work with my clients. I tend to keep my client base fairly small, so I have clients I get a lot of repeat work out of, and that's what I find better. Um, and part of that is they call me early, so straight away, this has now happened. What do we think, John? Okay, let's think it through. One thing I should say with RC is I don't think any person has the answer for every RC matter. It's got to be a team approach, and we've got to talk through that. But I'm with you. If we can get in early, it makes a really, really big difference. One of the complexities we have, and I'm not across Queensland enough yet, Aileen, is that um, sometimes agencies take quite some time to get back to you, the regulators. So if you're waiting for the regulator to decide if it's RC or not, you're actually the one position is you can't actually do inquiries in that point in time because you're not sure from a financial perspective whether you should start the investigation process. But obviously that's then leading to memory loss and contamination of evidence and so on and so on and increasing risk. Other clients, and I've certainly done the same over the years, is if a matter's clearly going to be RC, then we just make a decision as RC and just launch straight in, and that way we deal with those risks as we go. So these are considerations I think, yeah, Aileen, it's good to start thinking about. One of my concerns with is if we don't think about that early, you're going to come July the 1st and you're going to have complaints come in and you're not going to have your system set up to deal with it. And so from experience, we want to get in there early. And I say that because I've lived that experience myself and probably in reflection could have been a bit more organized.
Thank you. There's also one more comment that's not a question, John, but Vicky has answered a bit about the qualifications for investigations. For anyone that's interested, Vicky has said that Reportable Conduct Scheme in Victoria recommends investigations have this level of qualification, a Cert 4 in government investigations.
Yeah,
Just so that we're all informed. But John, I would like to say a huge thank you. We've hit 2 o'clock. I know that it's the time that everyone's ready to hang up and run on with their days. But I really appreciate you sharing with us today. The reflections have been wonderful. For everyone who joined today, the recording will be available next week. I'll send it out via email to you. But John, thank you so much. We really appreciate everything that you've done for us in terms of sharing.
no dramas. Thank you very much.
And everyone else, thank you and goodbye.